Before looking at your BAC result or field sobriety test, the first question is, how did this contact begin? A checkpoint stop and a standard traffic stop are governed by completely different constitutional rules. Getting that wrong early means building a defense on the wrong foundation. The type of stop shapes every argument that follows. When an officer pulls you over on a street or highway, the Fourth Amendment requires a reasonable, articulable suspicion that you broke a traffic law or that your driving suggested impairment. Common triggers include an unsafe lane change, a broken taillight, or weaving within a lane. If that suspicion did not exist the moment the officer activated the lights, every piece of evidence gathered after that moment may be suppressible under Penal Code Section 1538.5, which is the motion to suppress evidence. A checkpoint is different. Officers do not need individualized suspicion to stop you there, because courts have approved properly conducted checkpoints as constitutional. But the checkpoint itself must meet strict requirements. Supervisory personnel must make operational decisions, vehicles must be selected by a neutral formula, safety precautions must be in place, and the stop must be as brief as possible. Advance publicity is a factor courts weigh, but the California Supreme Court held in People v. Banks that a missing press release does not by itself void a checkpoint. A complete failure to publicize, combined with other problems, does strengthen a challenge. If the agency cut corners on any requirement, the entire stop may be challengeable. In both cases, the defense tool is a motion to suppress evidence under Penal Code Section 1538.5, but the argument inside that motion looks nothing alike. In a traffic stop case, you examine whether the officer truly had reasonable suspicion before activating the lights, which means reviewing body camera video, dashcam footage, and dispatch logs. In a checkpoint case, the focus shifts to whether the agency followed every procedural requirement, so you request the operational order, the supervisor's logs, and any advance publicity records. The origin of the stop narrows or widens the front door of your defense. The officer's conduct during the stop determines what else may be available once you are inside. Regardless of how the stop began, the charges are most commonly filed under Vehicle Code 23152, which is the impairment count, and Vehicle Code 23152, which is the per se BAC count. The stop type does not change what you are charged with. It changes how strong the prosecution's foundation is when they try to prove those charges. There is also a separate DMV hearing about your license, and the legality of the stop matters there too. In a checkpoint case, the agency must produce documentation showing the checkpoint met constitutional standards, and if it cannot, that is a viable argument for saving your license. At a checkpoint, field sobriety tests are sometimes given under difficult conditions: uneven pavement, flashing lights, or heavy traffic noise. Those conditions are relevant to how a judge or jury evaluates the results. Whatever kind of stop you experienced, the officer is also required to observe you for at least 15 minutes before administering a breath test. After any DUI arrest, the officer takes your license and gives you a pink temporary document called a DS-367. That form records information about the stop, including whether it was a checkpoint, and errors or omissions on it can sometimes work in your favor. Whether you were waved into a checkpoint or pulled over on the highway, the type of stop is the first piece of the puzzle, and it shapes everything that follows. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.